New law is now in effect in New York that could provide key information to adoptees about their past.
News 12's Danielle Campbell has more.
For almost 60 years, a New York state law denied Megan Kennenberg, who was adopted at 2 weeks old, a chance to discover her true identity.
Anger, because you want to know what your health characteristics are. You want to know where you got your eye color, where you got your height, your weight, everything.
Now, after decades of secrecy, a new law allows adopted adults in New York State unrestricted access to their sealed birth certificates.
If you didn't know where you came from, you'd want to know.
Today is the first day adopted adults 18 years or older can apply to obtain their original birth certificates, which includes the names of their biological parents.
Certificate number?
Since 1936, that access had been barred without a court order. New York State is the 10th and largest state to grant adoptees equal access to birth certificates.
If you went through 59 years of your life wondering, wow, it's going to be amazing.
Recently, through DNA, Kennenberg found her biological father, but her mother's identity remained a mystery until now.
I can't wait to find out what characteristics I got from her.
You can find all the information you need on the New York State Health Department website, and you just need one form of identification, like a passport or a license.
I'm excited about anything that I can find out.
Danielle Campbell, News 12, Long Island.
New Yorkers 21 years old and older can now possess up to 3 ounces of marijuana at home or in public. The new law has triggered immediate workplace concerns for both employees and employers. CBS 2's Jennifer McLogan spoke to an expert about the ramifications of legalized marijuana.
Long Island Main Street Alliance reached out to more than 70 businesses and employers tell us as they struggle to get out of the pandemic, they're overwhelmed with the new realities of pot.
This is another challenge that they have to face that they didn't quite expect, as local businesses were not involved in the shaping of the legislation.
If an employee comes in smelling like marijuana, we're limited to what we can do.
Smell would not be a symptom of impairment. Tricky situation for an employer to actually show that the employee was under the influence while they're working.
Attorney Avraham Geffen says it's a slippery slope as New York becomes the 15th state to legalize recreational marijuana, immediately allowing residents to possess small amounts. Legal sales are more than a year away. Pharmacy owner of Moby Drugs is also Farmingdale's mayor.
Can we zone them out of our downtown and into our industrial area? Is that also legal?
Limit the sales, limit the places in which it's allowed to be smoked.
You cannot legally smoke weed in a restaurant outdoor patio, and unlike cigarettes, you cannot smoke pot inside a car. Experts say the law on recreational marijuana is ahead of its time when it comes to technology and testing. Currently, companies are developing machines that may soon be a part of the workplace. In some states, businesses are buying cannabis insurance to protect against marijuana-induced workplace and roadway accidents. Kevin says these next months should be about advice and training.
Advising employees who may think that this is open season and they can come to work impaired, and also training supervisors to recognize what the signs of impairment are.
Documentation will be key to both employers and employees avoiding lawsuits. On Long Island, Jennifer McLogan, CBS 2 News.
As a family law practitioner, one of the areas that's extremely troubling, and one of the areas that's sort of become a focal point for our office, is parental alienation. I've spoken about this in groups, I've written on it, I've lectured on the topic, and I can't overemphasize how serious and long-lasting some of these psychological and legal effects can be. And just by way of definition, what we're talking about here really is the intentional interference by a parent with the other parent's relationship with the child. Okay. And that could be subtle, it could be drastic, it can actually damage and destroy the relationship forever. By way of history, this was not one of the major areas, at least it wasn't defined as a major area when I first started practicing, and even as recent as 20 years ago. Back then, we were dealing with allegations and false accusations of sexual abuse by parents to a child. And as horrible as that may sound, parental alienation may actually even be more insidious. Back then, we were talking about ways that parents would use this to gain the upper hand. Now we're talking about more of a psychological issue that needs to be addressed. And so courts they became aware, they became keenly aware on how to deal with the sexual allegations. So did attorneys for the children, practitioners, and family. And so some courts even went as far as saying that one false allegation of sexual abuse can be so egregious and damaging that in and of itself can warrant a change in custody. So the focus has shifted. Now we're starting to see reports to Child Protective Services and other similar agencies which don't reference sexual allegations, references other complaints about the other parent. In a recent case, a mother made such reports, 19 reports, either by herself or at her behest, by doctors, police officers, and mandated reporters, reports against the husband. The court ultimately determined that all of them were unfounded, and as a result, found the action so egregious to switch custody.
So much for having me. I am a trust and estates attorney, and I am also an elder law attorney, which they kind of mesh together, right? So trust and estates is the big umbrella, and it comes in different parts. So we have estate planning, we have estate administration, and there's this little niche of elder law that not all trust and estates attorneys do, but I happen to practice in the elder law field. And it actually does coincide a lot with what Johnny was just talking about. A huge part of my practice is working with all types of families, young families, older families, children of clients, clients that are found in situations where they may need long-term care. So planning to me is the most important part of trust and estates. I think that it's at the base, and I try to motivate people to get their estate planning documents prepared, so that in the event they had some sort of traumatic injury or an accident or something, they'd have their documents in place. And really that's again, for everybody over the age of 18, really. In planning, a lot of people have the misconception that it's just a will, but a will is really just one of the 4 documents that people need. The most important document to me is called a power of attorney. Power of attorney is the one document that I don't want people leaving without from my office. It essentially nominates who's going to be helping you in the event that you do need the help, the assistance. You can't get to the bank. You can't call the insurance carrier. You can't access your records because whether you're in some sort of condition where you can't speak or communicate, or maybe you're homebound, maybe something else is going on that you're not able to attend to your daily affairs. And so that power of attorney is very important for people to have. It can absolutely be misused if it ends up in the wrong hands, but that's why it's also very important that you prepare your paperwork ahead of time and you put the people that you fully trust to stand in that position. Unfortunately, a lot of people get taken advantage of when they may be at a time where they're vulnerable, they may be sick, or the people that come around them are not the ones who would have normally been around them when they were healthy. So, planning ahead of time ensures that you're putting the people who you trust to facilitate and take care of your affairs in the event that you couldn't do it yourself. So along with the power of attorney, we always recommend a healthcare proxy, which says who's going to make your medical decisions in the event you couldn't advocate for yourself. A living will, that's the 3rd document, that states that actually states what your end of life decisions are. And so your healthcare proxy would essentially be guided by that living will document that may say that in the event that you were in an incurable or irreversible medical condition with no reasonable expectation that you would recover, you're telling your healthcare agent you can withhold or withdraw artificial means, hydration and nutrition. So that would help guide them instead of just springing it on them that they should make the decision, without any guidance from you.
Hassig, and welcome to our live special report, The New Normal. This pandemic has been so hard on our families, especially families who have divorced parents and split their time between two homes. So how do families now work to get back on track? And is there a way for one parent to make up for lost visitation? There's so many different issues, and today we're getting some answers from Joseph Trotti. He's an attorney and partner at Vishik, McGovern and Melizzo. Before we get to Joe, we do want to hear from you. So for the next half hour, we will be answering your questions. You can submit them on our social media pages right now. All right, thanks so much for joining us this morning, Joe. And this is such an interesting time that you've been navigating for these families. So talk to me about some of the legal issues that have come up here.
Well, good morning, Elizabeth. So the issues that have come up are really, and the calls that we're getting from our clients is, how are we going to deal with parenting time during the pandemic? How are we going to deal with school and daycare? How are we going to deal with all of these issues? For example, daycare is such an important part of parenting time because the parents have to allocate who is going to take the child, who is responsible for the period of time, and then what happens with the pandemic when there no longer is daycare, and then we lost school. These are all the calls that we're getting from our clients. These are what we've been trying to navigate through and resolve, and that has been a steady basis since mid-March.
And how do you navigate these custody issues? Is there any real guidance out there?
Well, as far as custody issues, a lot depends on, is there a case pending? If there's a case pending, it's a little bit easier because there are attorneys involved. There perhaps is an attorney for the child involved. As you know, in all court cases involving custody and parenting time, the court appoints an attorney for the child. And so you have a representative of that child that you can speak with. So those cases are a little bit easier because there's something pending, there's something going on. Maybe there's an agreement in place that we can talk about and try to modify or resolve with an advocate for the child involved. It's a little more difficult if there are no cases pending and we are not allowed to talk to the children if we're representing a party. Those present problems, and those are where the interesting issues arise.
I know one of the biggest questions right now on the mind of most parents is, what's going to happen with schools? And if parents have different levels of comfort in sending their kids back to the classroom, what kind of information would you give them in trying to make this decision when they're maybe not, living together in the same house and making joint decisions?
So that's an interesting question, Elizabeth, right? So the first issue is what's going to happen with schools. Is it a state issue? Is it a federal issue? Look at clearly the governor is saying it's a state issue. Clearly he's going to impose his mandate and he's got a protocol in place. And I think August 7th he'll make a decision on which way we're going to go. So that's one issue. The second issue is what arises when parents disagree on the safety of the children. And remember, the courts are there to resolve some of these issues. And the courts will always be looking to see, is this truly a pandemic safety issue? Or is it really an alienation issue where one parent is trying to get more parenting time or custody, or worse, get child support based on these changing circumstances by invoking the safety tag and saying it's really a safety issue. And that's where I think interesting issues are going to arise. And I think that's where the courts are going to be challenged as to what is the background, what is the basis here for this parent saying they are comfortable or not comfortable letting the child attend school. I think it's a two-part question.
Yeah, and we've also heard the president, of course, weighing in on this, talking about, possibly defunding schools. And then you hear the governor saying that, no, these are state decisions, period, that is the law. So what is the law when it comes to educating our kids?
In researching this, it appears that it is a state issue. I believe that the governor is correct on this and that he has the final authority on how he is going to handle the education issue. And I think that the governor is already putting in place with a task force what are going to be the protocols? What are the safety issues? Is there going to be filtration system? Maybe pods? Is there going to be more outdoor activity? I think that they're doing their research right now so they can come up with the correct answer. But I think it's going to come down to the states. I think the president is going to try to do what he can to help the economy. I think that's his mindset. But I think ultimately it's going to come down to the governors, and I think it's going to be their plans that are going to be put into effect, whether it's in August or September of this year.
From Vishnik McGovern Malaysia. I'm one of the partners of the Trust Estates and the Elder Law departments. We have a full service firm, which involves a lot of different departments. We have a real estate department, matrimonial, employment law, personal injury, and essentially we can help our clients with a lot of the different things that they may need on a day-to-day. So thank you so much for having us. We're happy to be joining this, and we're glad to see that there's several people who are interested in what we have to say today. So I'm going to try to speak generally about a lot of different things, and then we can have some questions for the end. We always love to host these because we think there's a lot of information that needs to be given out to the community. I think a lot of people think that estate planning or Medicaid planning is for a specific type of person or individual. In fact, estate planning should really be done by everybody. Once you're an adult, you should have an estate plan. There are several documents that you should have. And so I always say at an absolute base, you should have 4 legal documents. The first one is the most important document to me. It's called a power of attorney. The power of attorney is the document that states who would make your financial decisions and who would assist you. They can help you now, or they can help you in the future only if you became incapacitated, or they can help you at all times. The power of attorney that comes into effect right away is called a durable power of attorney. It allows somebody to stand in your shoes to help you make financial decisions, whether it be contacting your insurance carrier, dealing with your bank, if you have tenants, dealing with your tenants at your home, making phone calls for you, just basically being your representative. And the durable power of attorney is in effect the minute you sign it. As long as you and your agent have signed it, they're in effect. Now, the springing power of attorney is the second type of power of attorney, and that document only comes into effect when you don't have capacity to make decisions for yourself. So the durable power of attorney, I'm sorry, it seems there's some, can everybody hear me? Is that okay? Okay, I just got a request to speak louder, so I'll try to speak louder. The springing power of attorney will only come into effect when a physician advises that you're not capable of handling your finances. And so a springing power of attorney can be used by individuals who prefer not to have something that's durable, that goes into effect right away. Now, for either type of power of attorney, if you're capable of making your own decisions and you decide that you want to be in charge of making a certain decision, then in that type of situation, your agent doesn't have the right to take over your decision making. As long as you're capable and you're fine, you're still in charge. So it's important to keep that in mind with the power of attorney. The most other important thing to note with the power of attorney is you have to make sure that you put the right people in charge. It's got to be somebody that you trust, someone that you know is going to make the best decision on your behalf, and someone who you know is going to be savvy, right? They're going to make a good decision regarding your finances. They're going to make similar decisions to you regarding your care, where you should be living, who should be taking care of you and things like that, because that's what a power of attorney does. So it's very important that when you prepare this document, you keep all of those things in mind. That one is the first document. The second document is called a healthcare proxy. The healthcare proxy is the document which states who's going to be making your medical decisions if you could not make them yourself. So if you are not capable of communicating your medical needs, your medical decisions, if you weren't able to advocate for yourself in a hospital setting with a doctor at a facility, this is the individual who would stand in your shoes to make all your medical decisions, to accept certain types of treatment or to reject certain types of treatment. That would be your agent under your healthcare proxy. Now, your healthcare proxy, you have to name your agents successively. First, then second, then third, and if you want to keep going, you can keep going as far down as you want. But your agents have to be successively because doctors, medical professionals, they don't want to speak to 2 or 3 different people. They don't want to have fights between 2 or 3 different people. So there should really be a successive order of these individuals. The third document is called a living will. The living will states what your end of life decisions are. It says, in the event that you are suffering from an incurable or irreversible medical or physical state,
So this morning we're getting some expert advice, and Avraham Geffen is a partner at Vishnick McGovern and Melizio's litigation practice group, and they specialize in commercial and employment litigation. Do remember, we want to hear from you. For the next half hour, we'll be answering your questions live. You can submit them right now on our social media pages. All right, so navigating your return to work, to your office, it can be tricky. And what can your employer really expect from you? And what can you expect from your employer? We're going to get some of those answers right now. So thank you so much for joining us. I guess I want to start with what, for businesses that are now reopening, what are the things that they need to be considering?
Good morning, Elizabeth. Thanks for having me. Appreciate being here. Some of the things that businesses need to consider and need to have, some of it's optional and some of it's recommended, some of it's actually required, is a plan. One of the most important things is to have a plan to go back to the office, how they're going to operate once they reopen. The state has a template that any business can use, but you're not required to use that template. And although it's not required to be filed with the state, every business must have it on file, and the state is allowed to ask the business for a copy of it in order to make sure that they have a plan in place. The plan can be things as important as, which seem kind of intuitive, socially distancing, having a capacity that's only 50% of the maximum allowed capacity for that particular location, not congregating in public places. And then there are things that are more of suggestions or recommendations, such as staggering work hours, perhaps having a schedule where 50% of employees come in on certain days of the week. Obviously, this is not possible or practical for some businesses, but it is recommended.
Now, I know one question we seem to get nearly every week on this show is from people saying, what if I'm not comfortable going back to work? So what happens then?
Well, the answer is that an employer can generally require employees to come back to work if they just simply have a fear of coming to work. However, there are exceptions to that. For example, if there is an employee that has a particular susceptibility or reason why they cannot come to work, then a business has to at least think about or consider giving that person a reasonable accommodation, which may include allowing them to continue to work at home.
Okay. Now, if a worker does have an existing health condition or, something like a compromised immune system, do the employers now have to make certain changes? Are there regulations in place to, protect the workers?
It's really a case-by-case basis. The fact that a person, for example, is older, which is one of the conditions that can cause a higher rate of susceptibility to the disease, and obviously if an older person actually gets the disease, they're more at risk for serious complications than a younger person. But there's no bright line or blanket rule that says that I have to give an accommodation to an employee just because they say, I don't feel comfortable and I feel susceptible. Every case has to be evaluated. There has to be a dialogue between the employer and the employee to find out whether or not an accommodation is necessary and whether an accommodation is actually required under the law. And there are federal laws as well as states laws as well as local laws that guide employers in these types of situations.
So OSHA obviously requires that employers provide a work environment that's free from recognized hazards that are, likely to cause any physical harm. But how do places of business navigate that now?
Well, I think a lot of businesses are first becoming familiar with OSHA now. Businesses that never had to consider it or never really thought about it. Usually it's the construction type businesses that think about OSHA, not a office environment. But you're correct that OSHA now is requiring or always required a safe business environment, which was never really an issue for most offices, but now it is. And the thing about the OSHA requirements is that if you follow the guidelines laid out by the state, then you will be in compliance with the OSHA guidelines. So it's important for businesses to develop a plan, and the plan should include these safety and precautionary methods such as social distancing, not gathering, staggering work hours, not congregating.
Now, what if an employee feels like their boss isn't doing the right thing to protect them? What can they do?
Both New York and New Jersey, and I'm getting this question from employers as well as employees who are clients of mine who want to know what are my rights and what are my obligations. Both employers and employees have to use a common sense approach to this. And if an employee is complaining about something or doesn't feel safe about something, the employer, even if they think that they're following the guidelines, should take that into consideration and should consider making an accommodation even in the office to address that specific complaint that an employee may have. There are ways that an employee can file complaints. Both the New York State and New Jersey have links on their website to file complaints by employees against employers if they feel like they're not complying with the law and creating an unsafe environment.
Now, does an employer have to tell the people who work there, what area, if somebody were to test positive? Because I remember, I think it was maybe 2 weeks ago, we saw this come up with Amazon, where the workers were saying they wanted to know what shift the person worked who tested positive and who may have come in contact. But that kind of puts them in like a sticky situation because you don't want to also hurt the person who tested positive and maybe have them be ostracized in the future.
Sure. And there are privacy considerations that employers have to take into account when they're doing this. They have to do it in a way that, as much as possible, allows the employee who tested positive to remain anonymous. In other words, they would say an employee who worked in this area during these hours tested positive rather than this person tested positive. And that's one way that employees can both try to protect the privacy of the employee who tested positive, as well as keeping the other employees in the loop, allowing them the information necessary that they can take any precautions they have to take so that everybody is protected.
Welcome, everyone. Again, my name is James Birdie. I'm with the firm Bishnick McGovern Melizio. We're based in Lake Success. I grew up in Hollis, Queens. I got my BA in government and politics from St. John's and my law degree from St. John's. So, just down the road from your school. And as Lori said, my practice right now is primarily in trusts and estates. Wills, trusts, guardianships, adoptions, special needs planning. But prior to concentrating my practice in that way, I had a more general practice. So I have a background as well in criminal defense work, landlord-tenant, consumer debt, divorce, and real estate. In other words, many of the things the average person confronts in their life in the legal world. And as you'll see as we get on into this webinar, trust and estates is not just for the old and not just for the rich. There's a place for estate planning for everyone. But what's this webinar about? It's about you. Most of you are just about 18 years old, maybe 19, and this is a very critical age from the standpoint of the law. You have more rights now as an adult. You don't need parental consent for most things that you do. Excuse me if we just blacked out there. I think we're back now. But in addition to having more rights as an adult, you also have more responsibilities as an adult. And it's kind of a paradoxical age. On the one hand, many of you are still very, very dependent upon your families for financial support. Many of you may still live at home. On the other hand, you've reached a point where your thinking is independent, your conduct is independent, you're making career plans, and it's important to explore what the legal aspects of all these responsibilities are. So why would I present this? What I found in my practice is that a lot of young adults encounter problems with the legal system just because they don't have enough background to confront it correctly. They get tied up in leases or promissory notes that they didn't understand the meaning of. They have problems accessing health records. Maybe their bank accounts still have their parents' names on them. So I want to give you an overview of what you're facing in the legal world now that you're a young adult. So we'll start with the basics. The basics are the age of majority. Okay, for federal and state purposes, the age of majority is 18. Okay, I'll concentrate first on the federal. As you know, New York and the federal government both have their own bodies of law that you're subject to. Most of the time, it's New York law that you have to deal with. But again, there are some federal matters that affect you. For one thing, the voting age, as you probably know from the past month, the voting age for a presidential election is 18. At 18, all males have to register for the draft. At 18, you can be called for federal jury duty. And at 18, if you're charged with a federal crime, you can be tried as an adult. Okay, New York, there are more ages for more things. Okay, and I'm going to tick off a list of things that the age of 18 applies to. We'll come back to them in more detail after I go through the list. Voting. Voting is age 18 in New York. Litigation. Your right to sue and to be sued kicks in at 18. Okay. At 18, you can enter into binding contracts. Once you're 18 years old, your signature on a contract will bind you. Okay. Your parents no longer have the right to access your medical records or your personal records without your consent. And they no longer have the right to direct your medical care. Okay, you control your medical care, you control access to all of your records. This is a two-edged sword, though. There may come times when your parents, especially if you're on their health insurance, might need to access your medical records in order to get something paid. They can't do it without you. Okay, there are ways to work around this, which we'll go into later on in the webinar. The age to consent to marriage in the state of New York is 18. With court approval, you can also get married at 17.
Knocked down so many trees all over the tri-state area. So who is responsible if one fell on your property? As CBS 2's Andrea Grimes reports, the answer may surprise you.
A huge job on Harvard Street in Garden City. Village workers cutting an enormous tree that fell across the street onto John Dwayne's truck and property.
Well, the village is doing it, but it's a tree. As far as the damage, the insurance companies will have to fight that out. I don't know who's going to be responsible.
Yeah,
woman. That's not me.
Unfortunately, Dwayne is not alone. Tuesday's storm tore down tons of trees across the tri-state area, from those owned by towns, villages, and cities to trees owned by private citizens. So who's liable if one fell onto your property?
People are very surprised to find out, you know, you own a tree, you own the property, your tree falls on somebody else's property. People are always assuming it's your fault and it's your liability, and that's not the law. That's sort of the exception to the law.
Personal injury lawyer Richard Apat is from Vishnick, McGovern, Melizio in Lake Success. He says the private tree owner may be liable if they knew the tree was decaying or there were outward signs of decay.
Absolutely. That would be a good liability case, whether it's talking about property damage or personal injury.
When it comes to trees owned by a city or municipality,
you need to file what's called notice of claim. But in terms of their liability, it's generally going to be the same for trees. They have an affirmative obligation to do some inspections.
APAT says in the 5 boroughs, only the city can maintain a tree on city property, even if it's technically in front of your home. If it falls, you have a much better case if you expressed prior concern about it in writing. APAT says when dealing with neighbors, speak to them, let insurance companies deal with it, and to the extent there's a deductible, if you can work it out among yourselves, that's always the best way to go. In Garden City Park, Andrea Grimes, CBS 2 News.
Now, Brooklyn Councilman Justin Brannon says New Yorkers are allowed to hire a private contractor to remove a city tree if it's snapped in half and is laying across the street, but you will not be reimbursed.
People already trickling in, so I'd like to welcome everybody. Good afternoon. Thank you for joining us. And this the first of the ongoing joint Northwell Health, Vishnick McGovern Melizio LGBTQ Health and Life Planning webinar series. This will be an ongoing webinar series launching today, and then we're going to have 4 weekly sessions during June, which is Pride Month, and then with some frequency to be determined following. Each webinar will deal with a different topic. Today would be primarily HIV, PrEP, and LGBTQ health from the medical perspective, and estate planning from the legal perspective. I'd like to take this opportunity and also tell you that tentatively set for July 8th, COVID conditions allowing, we will be starting a joint pro bono trans clinic designed to inform and support transitioning people and their families through all stages of process with medical and legal needs, name changes, gender marker changes, healthcare proxy, powers of attorney, et cetera, et cetera. We will be sending out more information about that as the time nears. To those of you, there are a couple of names that I don't recognize from our client list, so to those of you who are unfamiliar with Vishnick McGovern Melizio, or VMM, we are a full-service law firm providing a comprehensive, tailored legal services to all your personal and business needs. We have 3 offices in New York City, in Lake Success, Long Island, and in Oakhurst, New Jersey. Our LGBTQ representation practice, which Mr. Melizio leads, he is also the managing partner of the firm, is one of our most robust practices, and it's one of the very first in the nation. It's one of the oldest in the country. And it's specialized, it's very multifaceted. It includes things like employment law and estate planning and family law and other aspects. And again, designed to provide really tailored and comprehensive solutions to all the needs.
Thank you for being here today and joining us to talk about issues that come up in elder law. I am an trust and estates and elder law practitioner, and I've been doing this for about 25 years. And what we do as elder law practitioners is that we facilitate the legal issues that are very common and come up within the estate planning arena, the health care arena and the like for people who are older and need assistance in that regard. So what we want to focus on is very much like what we want to focus on for anybody that we're doing estate planning for, but there are additional considerations and additional things that must be looked into and thought about as people age, such as dealing with the potential for elder fraud and elder abuse, making sure that the long-term care costs of the person who we're planning for has been considered and is going to be well handled and planned for, and also to consider what happens in the event that this elderly person is not able to make healthcare decisions for themselves at some point in time, or is not able to make financial decisions, handle their checkbook, pay bills, etc. And these are the things that we want to focus on and consider when we're meeting with families. Typically, when I meet with a family, I'm not just meeting with the elderly party. I'm very often meeting with the spouse, the children of the party who's looking to do the planning, and we are going to want to get a lot of information before we can really guide them in terms of what is needed in any person's particular circumstance. Okay, so let me just start by talking about the basic documents, and this really applies to just about anybody who's doing estate planning. There are certain documents that everyone should have in place, and sometimes when I meet with a family, they already have some of this in place, and sometimes they don't. But certainly, if they do have them in place, these documents in place, I want to see what they have in place. I want to see if there's any major changes. And this is, I'll get into that in a minute in terms of, comparing the old documents to what we have now or what's being proposed. But just in general, the documents that we always want to see that everybody should have is a power of attorney, a healthcare proxy, sometimes a living will, and a will. Okay, and then we get into trusts, and people always want to know about trusts and why we use it and how we use it and all that, and we'll talk about that. But generally, basically, the things that everyone should have, even at a younger age, are these 3 or 4 documents. So the first one is the power of attorney. Power of attorney is a document that is used to give someone else power to sign for you or for your loved one, to deal with banking, to deal with real estate, to deal with any kind of assets or income or Social Security and all these things that have to be dealt with. Because we all have to be mindful, even at a younger age, that there could come a time when even though I want to be able to handle everything for myself my entire life, but there could come a time when I'm not able to do that because of some type of incapacity. So because of that, we want to have that first document we want to make sure everybody has is a power of attorney. And the power of attorney, again, is putting somebody in place to make these kind of decisions, financial decisions, and to sign for you or for your loved one in the event that they can't do it for themselves. And there are 2 or 3 different types of power of attorney. One is a springing power of attorney, and that's power of attorney that can only be used if the party becomes incapacitated. And some people don't feel comfortable giving either their spouse or their children or a friend or whatever power immediately to sign for them or to go to the bank and withdraw money or to sign on a real estate transaction. But they will feel comfortable in the event they ever become incapacitated. So some people only want to do a springing power of attorney. Others will do what we call a durable power of attorney. And a durable power of attorney is a power of attorney that can be used today, tomorrow, the next day, even if the person who's giving power of attorney, becomes incapacitated. In other words, by putting a durable power of attorney in place, I am immediately giving power to that person, whether it's my spouse or my child or somebody else, the power to sign for me. That doesn't mean I'm giving away my rights to sign for myself. It just means that I'm adding to the people who can sign for me. And sometimes I'll give it just to one person. Sometimes we can give it to several different people, or we can give it to them in a certain order of priority. First A, then B, then C. And the reason it's so important to have this, now the one type of power of attorney that you don't want to have is one that terminates in the event of incapacity. And so you want to make sure that it's done properly. The other thing is that, there are a lot of forms out there, powers of attorney, that people, they just go out and sign a form. Unfortunately, 90% of the time when somebody comes in with a form that was signed maybe when mom or dad was in better condition, was notarized and everything, there's always some type of a problem that I find with it in terms of our being able to do the planning that needs to be done for elderly people when they are no longer able to do it for themselves. One of those things is the ability to make gifts, the ability to set up trusts, and to make transfers.
Vishnik McGovern Malizio has had its doors open for many, many decades, but over the past few decades, we've acquired a specialty and expertise and its sensitivity with respect to representing individuals who have LGBTQ issues and concerns, and we remain sensitive, respectful, and knowledgeable in our representation of individuals from the LGBTQ community.
There was no adequate representation when I came out as a gay man 15 years ago. I came to my business partners and I said, I'm really not feeling comfortable as an attorney with having an attorney that can properly represent me in all of my estate, family, legal, business, and personal issues.
And what has surprised me over the years of representing LGBTQ clients is the fact that several of them have told me at the conclusion of their cases is how they were surprised at the amount of respect they received from our firm when we represented them. And I had just assumed that would be the case in other instances with other law firms, and I was repeatedly told that's not what they encountered. They felt good with us, they felt comfortable with us, and they felt as if they were given their due respect.
When we have clients come into the office, one of the things that I think that they feel right away is this comfort level, this empathy that we have, and for an appreciation for what they've been through, and hopefully to alleviate some of those problems in the future, whether it's in custody battles or employment law or whatever other areas there may be.
The greatest compliment I've acquired, or received rather, is thank you for treating me with respect.
I generally feel around this time of year between Valentine's Day and April 15th is a good time to have a conversation about gifts and taxes. Gifts, which hopefully were exchanged on Valentine's Day, when given during the marriage between spouses, they are considered marital property and therefore subject to distribution at the time of a divorce. A gift from a third party, however, to one spouse is separate property and the party keeps it. So the running joke, the irony is that if you have a gift from your spouse, you have to divide it up at the time of divorce. But the gift that you get from your boyfriend or girlfriend, you can get to keep. All jokes aside, and irony aside, there are important, serious economic, financial considerations about this theory. And so what we're talking about is a gift made from a third party. If that spouse is able to keep that gift separate throughout the marriage, then at the time of divorce, not only is the gift, but also the appreciation, that will be separate property, not subject to distribution. And now when we think about gifts, we usually think about rings or bracelets or watches, but it applies to all gifts. Real estate, transfers of interest in property, trusts, stock options, bonds. All of these are gifts. And so the consequences are greater because we're talking about gifts of greater value. What happens if a spouse during the divorce says, well, that gift from a third party was to the parties, to the marriage, not just to one individual? Well, then the courts will get involved. And when they do, they may look to the donor, the one who made the gift, because under the law, the donor has to file a gift tax return. And in there could be important information as to the value of the gift and, more importantly, who the gift was made to. And it's not uncommon for courts to look at tax returns. In fact, they frequently look at tax returns to find out what are the real income of the parties, their assets, and who's really telling the truth. Now let's talk a little bit about taxes. The question that I get asked most often is when the parties divide up the marital estate, is that a taxable event? And the answer generally is no. So for example, if there's a house that's worth $600,000 and the husband is going to buy out the wife and give her $300,000, that event is not taxable. So what about child support? Same theory, not taxable. How about maintenance, or what was formerly known as alimony? Well, that used to be a taxable event. The payor used to be able to deduct it, and the payee would have to pay income tax on it. But that is no longer the case under the current law. It is not a taxable event. So, I said earlier, generally the answer is no as to taxes, but there are important considerations that people should understand when we're talking about this. One is that on a marital home, there are two exemptions that our parties are entitled to. Each party gets a $250,000 exemption. So the first $500,000 of gain on the principal residence is not taxable. Okay, but what happens if the gain is more than $500,000? Well, then the party that's buying out the other party, they need to consider that, because when they sell the property, they'll have a tax consequence, and that should be factored into what the other spouse is getting. What happens with this 250 exemption if one party trades off their interest in the house? They sign a deed. Now the party retaining the house has the principal residence only in their name. Will they be able to get the $500,000 exemption? They need to consider that. And thirdly, this exemption issue only applies to principal residences. It does not apply to other parcels of real estate. For example, the second family, the vacation home, the family house that they purchased, the commercial property. It does not apply there. When those properties get sold, they are subject to capital gains tax. And so if the parties are going to divide up the amount of the value of those assets, they need to consider the tax consequences to divide it fairly. A couple of issues that also come up with this is, one is dividing up other assets to make sure that we have a fair division. And so when we're talking about real estate, let's say we have two pieces of property, both worth $600,000, both with a $300,000 mortgage on it. And the parties say the wife gets one and the husband gets the other. Is that fair? Well, maybe, and maybe not. Why? Because you have to factor in what the cost of that property was. So for example, if the wife is getting the property A, and it's worth $600,000, but she paid $100,000 for it, or the parties did $100,000 for it, then it's gained $500,000, and there'll be a significant tax when she sells it. If the husband retains the property and it has $600,000 of value on it, but they purchased it for $500,000, then the tax is going to be much, much less. And that has to be considered between the parties when they're trading off. One last point, and we hear this all the time. My spouse is really making a lot more with the business than he's declaring. That business is worth a lot of money. There is a lot of income generating. He's not declaring it. What will the courts do then? Well, yeah, they'll look at to see what the lifestyle has been, what the expenditures have been, but they'll also ask an important question. How were the taxes filed during the marriage? Were they jointly filed? Was it a joint tax return? If it was, then the court is going to say, well, You're making that complaint now about income, but all those years you were attesting to the fact that the business was making less, and that could be held against you. And so we don't often think about how we're going to file taxes when the marriage is going well, but it is an important factor to be considered when the marriage ends in divorce.
People who are adopted in New York State can apply for their original birth certificate. This also means it's possible those adoptees could find their birth parents. News 4's Paisy Cheng spoke to a woman impacted by this development. She's live in Williston Park. Paisy?
David, this woman that we spoke with was adopted as a baby and said that she has walked down streets all the time wondering if the person passing her is related to her. Well, now this sort of information is no longer a secret because of this new state law, a law that promises to change lives.
Everybody else gets to see where they got their hair color, their eye color, their everything.
Megan Kettenberg, now 59 years old, always wondered who her biological parents were. Megan was a baby when she was adopted.
Everywhere I went and I looked around, I'm like, I wonder if I'm related to that person, you know, anybody that some even look like me. I wonder if they're related.
She was able to get some information about her birth parents from the adoption agency in 1994. Her mother was a 26-year-old single woman of German descent. But it wasn't until she took a DNA test that led her to her birth father's family. He had passed, but she learned about 5 half-siblings.
Overwhelmed.
The DNA test did not connect her to her mother's family, but after filling out this form, she will finally be able to learn her mother's name.
With the changes in the new law, they will give identifying information and all medical information that's contained in the file as well.
Attorney Joseph Malizio says this new state law effective today clears hurdles for adopted children.
It was necessary to petition the court, have the court order the sealed file be opened, and that rarely occurred.
For Megan, this marks the end of a lifelong quest for self-identity.
It answers a lot of questions. It's a lifelong, like, where did I come from? Everybody else gets to know, why shouldn't I?
And these forms are available online. If you were born in a New York City hospital, it'll only cost you $15. Outside of New York City, $45. We're live from Williston Park tonight. Paisy Cheng, News 4 New York.
So ABC Corp is a business which I have worked with on and off for a number of years. They're a dry cleaning business with locations throughout the New York metropolitan area. It does all its dry cleaning work in-house, and it employs over 50 people. The stock of ABC is owned by mom and dad and son. Father and mother live in Florida. The business is operated exclusively in New York, and therefore mother and father are for the most part absent owners. Daughter was brought in a few years ago as a temporary controller when profits started to fall. So father was the original owner of this business. At some point, he gifted half of the stock in the company to his wife, and each of them then subsequently gifted 10% in the aggregate to their son. Son is now the president of the entity, and he's also a director. Mom and dad are the other 2 directors. Daughter, after being brought in and started going through the books, began to notice some inconsistencies in the records. Over time, she found that there was a line of credit that the business had, but there was no record of the line of credit on the corporate books. Moreover, it was fully drawn on to the extent of $250,000. Neither father nor mother knew about it, and son was apparently very good to himself. In addition to fully drawing down on the line of credit and putting it in his own pocket, he unilaterally increased his salary. He spent corporate funds on his personal needs. and he avoided paying suppliers and avoided paying rent for his various locations also. To make matters a little bit more difficult, daughter, in working there, was approached from many angles by various employees who told her that son, the president, was verbally abusive to many of their employees and that there were 2 discrimination suits pending. Daughter reported all of these incidences to mother and father, who had no idea of what was going on. Nevertheless, aside from taking some preliminary steps, and those steps were essentially to contact me and say, what can we do? And I went through a whole series of steps that they should have taken. The only thing they actually did was say, okay, it's time to sell this business. And what do we have on our hands other than a potential disaster? Well, we have a disaster, but let's look at some positives that were done first, because the negatives far outweigh the positives here. So I indicated that father was originally 100% owner of the business. He subsequently transferred 50% to his wife, who then together subsequently transferred 10% to the son. So they started to do some estate planning here. As business owners, that in my head is number one.
Hope tonight for couples struggling to conceive a baby.
Sorry about that, Tama. News 12's Jackie Lucas tells us about a new state law set to go into effect Monday that will actually help ease some of the strains in their journey toward parenthood.
Lisa and Muhammad of Valley Stream have been married for 6 years. The couple has always wanted kids, but Lisa can't carry her own due to medical reasons.
We've always wanted a family. And it was just kind of unfortunate with my specific situation.
They're now over the moon after learning that starting Monday, surrogacy will be legal in New York State. They'll be able to enter into a paid legal contract, and a surrogate will be able to carry their baby.
New York State is, they're a little bit behind the curve on it, but we're glad that they finally caught up, because it's already an expensive procedure. On top of that, it's nice to be done in your own state.
The new law has a lot of protections for the surrogate herself, who has to be at least 21 years old. Attorney Joseph Malizio says intended parents are required to provide benefits to the surrogate, like health care, life insurance, disability insurance, and legal counsel.
And the purpose of having representation is to negotiate a surrogacy agreement. And that surrogacy agreement is used both before the pregnancy actually occurs and after the birth of the child to cover everything regarding the pregnancy and the resultant birth.
Now, couples like Lisa and Muhammad won't have to travel out of state for someone to have their baby. They can't wait to start the process.
It's something that we were looking forward to, because we do have our own embryos that we wanted a surrogate to carry, and so we want to be available every step of the way. And by having that available to us from someone in our home state, we can be. I can be there from the beginning to the end, from the transfer to the birth, and I'm very excited about it.
I'm Jackie Lucas, News 12 Long Island.
Also going into effect, insurers will now have to provide immediate coverage for fertility services for same-sex couples. To learn more about surrogacy, as well as those new protections for LGBTQ New Yorkers, log on to our website, news12.com. It's all there. Click on numbers and links.